Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
The courts shall have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred. Stop. This section obviously postulates, among other things, the barring of the jurisdiction of the civil courts by legislatures with respect to particular classes of suits of a civil nature, and the statute book abounds in instances in which the jurisdiction of the civil courts is barred under acts passed by the central and provincial legislatures. Stop. There are also many acts providing that any suit or proceeding concerning the subject's matter of those acts shall be liable by the court or courts specified therein. Stop. Such provisions are to be found in a number of enacts both prior to and after the enactment of the Government of India Act 1935, and there can be no doubt that the British Parliament, while enacting that act, was fully aware of the existing legislative practice obtaining in this country, as well as of the fact that the provisions in question were sometimes necessary, and therefore it empowered the central and provincial legislatures to make them under entry 53 of list 1 and entry 2 of list 2 respectively. Stop. This, in my opinion, is the true meaning of these entries, and it also explains why a separate entry was necessary, enabling the two legislatures to legislate with regard to the power and jurisdiction of the courts in respect of the subject matters mentioned in the three legislative lists. Stop. But for an express provision like that made in the entries referred to above, the two legislatures might not have been able to confer special jurisdiction on the courts in regard to the matters set out in the legislative lists, nor could they have been able to bar the jurisdiction of the ordinary courts in regard to them, however necessary or desirable such a course might have appeared to them. The learned Attorney General, who appeared on behalf of the appellant in supporting the impugned act, argued before us that for the purpose of deciding this appeal we might also refer to entry 4 list 3rd. Stop. His contention was that the impugned act, having had the assent of the Governor General, it would be permissible to see what powers the provisional legislature could exercise under list 2 and 3rd taken together. Stop. If the course which the suggests it adopted, then the subjects on which the provincial legislature can legislate would be administration of justice, constitution and organization of courts, and civil procedure, including all matters included in the Code of Civil Procedure at the date of the passing of the Government of India Act 1935. Stop. One of the matters included in the Civil Procedure Code is the jurisdiction of courts. Section 9 of the Code provides, as I have already stated, that the courts shall have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred. Stop. There are also provisions in the code dealing with the territorial and pecuniary jurisdiction to the courts. Stop.